So welcome to Session1. So I'm happy to introduce the speakers for Session1. So first, Mr. Karn, so next to me. So he's a partner at a sport in the White Crime Defense and Investigation Group. He represents companies in government enforcement matters, internal investigations, and compliance matters, and successfully resolved a number of government investigations for companies and individuals, including FCPA, healthcare fraud, and security fraud. And next to him is Professor Jennifer Aren. So she is internationally recognized expert on corporate criminal and civil enforcement and director and officer liability and compliance. And she is the founder and the faculty director of the new university program on corporate criminal compliance and enforcement. And next to her is Lisa Osowski. Ms. Lisa Osowski. So she has served as a prosecutor, in-house counsel, monitoring reporting officer, corporate compliance monitor, and ethics advisor for both public and private sector organizations on both sides of the Atlantic. And prior to joining current position at RX Partners, she served as a director of the CS Fraud Office in the UK. Okay, next to her is Mr. Alan Milford. So Alan is a solicitor advocate who trained in a city firm and worked briefly as a civil litigator before deciding to specialize in criminal law. So he was over CS Fraud Office's general counsel, and the same in 2012. Yeah. And since then, so he worked for 6 years, and he was directly responsible to the director of the CS Fraud Office for all its casework. So since we have really good speakers here, and we can discuss the general update or development this year in the field of white-collar crime. And then in the later part, we use HIPO. So I circulated to you this morning, and then discuss various topics from US and the UK perspective, and sometimes from Japan. Okay, so let's discuss the recent development in the US and UK. And before digging into the detail, I'd like to ask Jennifer about your impression and what you have observed this year.
So, thank you. Thank you very much, and it's such an honor to be here. I was saying this is one of my favorite conferences. I suppose other than ones I organize, but even so, actually, this is even then one of my favorite conferences. And I look forward to learning from everyone in the audience and the panel. So, from my perspective, a significant amount of what happened this year is actually a big improvement over the past, or a small improvement at least. Just to quickly frame it, I'm a deterrence hawk. The most important way to deter is to simultaneously reduce the incentives employees have to commit a crime, but also to materially increase their risk of detection and punishment. And many, many studies show that the risk of detection matters more than the sanction. So the US tends to do a high sanction, low probability detection. That's been shown not to work. You need a high risk of detection for that to be something people take into account. So how do we get there? You need companies for both. Companies control the incentives to commit crime, so you have to make sure companies are not allowed to profit from crime. So they must always disgorge. Companies also are the best people to detect misconduct and help the government get the information it needs. So you need to incentivize them to self-report and to hand over evidence against the individuals. The DOJ in the many, many decades I've been doing this, has begun by saying, oh, we'll reduce the fines on companies for self-reporting, and that doesn't do it, because companies need to know for sure what happens. This year, they've adopted the strongest and most predictable corporate enforcement policy that really says if you self-report, fully cooperate, including by turning over evidence against individuals, and remediate, you can count on a declination, which includes disgorgement, which is really, really important, except in a few cases. I'm not enthusiastic about the except part, but even for the except, they offer much clearer guidelines on what you can get. And they've made it much less risky for companies that are self-reporting, who are afraid that they will self-report and only to discover there was a whistleblower, by saying if you self-report in good faith, you can still get sometimes a declination, other times an NPA. We're really going to highly incentivize it. This is really, really good news. And could, had nothing else changed, materially increase the incentives to report. Now, the incentives to report are only going to be higher if you increase the benefits of reporting, if you keep the risk of not reporting the same. As an outside observer who's not in the DOJ, it doesn't look like we've kept the risk of not reporting the same. There are fewer people in the fraud unit, as far as I can tell, and right now they're shut down. Okay, so there are more people, but they're not all over in the FCPA. I mean, there's been a reallocation away from, for example, the FCPA unit. And the new FCPA enforcement policy would send a signal to companies that if you're doing certain types of corruption, we're probably going to leave you alone. And so I think companies doing certain types of things will feel the risk of our coming after you is down. Now I should add, companies doing other types of things will feel the risk may have gone up. But that could undercut self-reporting of foreign corruption, and I can't tell as an outsider how active we really are about domestic corruption. Just getting it out of me. Oh, can I just add one? Oh, the other fly in the ointment is that the SEC, which has jurisdiction over publicly held companies, has not adopted an effective corporate enforcement policy that really provides a very, very strong incentive to self-report and cooperate, in my mind. And that's a problem.
So we can discuss later, so that's problem. And thank you, Jennifer. And so I'd like to ask Dan, so that's our recent development, so especially so about the DOJ policy or guidance. So so what happens in the US?
Yeah, I think there's a lot to talk about, so I'm going to try and be very, very brief because this is a wonderful panel and you should hear from them and you'll learn a lot more from them than you will from me. But I think there's a couple points, and Jennifer hit on some of them. I think one point is DOJ is realigning and coming up with different priorities. And I think there's no question about that. Put the FCPA to the side for a second. I realize that's a big thing to put to the side, but it's not unusual for administrations to come in and say, here are the crimes that we're going to focus on. And frankly, if you look at the crimes that Keith described, as the number 2 person in DOJ's criminal division, and the head of the criminal division came out with a memo outlining the priorities. They are traditional areas of enforcement, and a few newer ones like custom fraud and trade fraud, tariff fraud, as well as a couple other focuses on VIEs, which again, it's not as though VIEs from China have not been a focus in prior administrations, but they haven't been called out as much. So that's, I think, very normal for an administration. It's very normal for an administration to have a slowdown during the transition. The last administration, when they came in, had a much slower first year, and frankly, even the second year, there was a lot of press articles about, why isn't the Biden administration having more corporate enforcement? So, I think sometimes it takes administrations to ramp up. What is more unusual here are some of the pronouncements that have come out, the executive order on the FCPA, and that, I think, has called into question how the department is going to implement that and what the department is actually going to do. Now, you heard Keith talk about all the corporate enforcement that's going on, and there have been signals that it is going to continue to some extent business as usual. I think there's definitely going to be less enforcement of FCPA, but at the same time, if you look at the FCPA guidance, again, on its face, it's hard to look at that and say that's a crazy way to look at FCPA. I frankly think it is a very sensible way to look at FCPA enforcement, to say we as the United States are not going to be the world's policemen. We're not going to look for every random violation of the FCPA that we could jurisdictionally go after, and instead we're going to focus on ones that have a greater impact on U.S. equities. I think that's it's frankly a conversation that when I was in the FCPA unit we would have with foreign authorities all the time. The foreign authority would argue that they should handle a particular case because they have greater equities than the United States. And so it's not unusual in that sense. The FCPA unit is reduced in size, but not to the point where they don't have sufficient resources. They have it might be 14-ish people. That's a lot. I think you could do a lot with that level of enforcement, and I think most authorities around the world probably have less than that. So that's, I think, at a broad level, the level of enforcement. I think the policy, Jennifer is absolutely right. I think the corporate enforcement policy has taken a step in the right direction. And I think, frankly, over time, the purpose of the corporate enforcement policy has gotten lost because new administrations come in and they try to put their imprint on it and they try to, improve it, and it has the opposite effect. And so the last administration, I think with the intent of trying to improve the corporate enforcement policy, made it much harder to comply with by adding a bunch of hurdles that you had to overcome if there were aggravating circumstances. From a defense practitioner's perspective, from a company's perspective, what that meant was you probably didn't want to disclose because you never knew if there's going to be aggravating circumstances until the end of the investigation, and it makes it much harder to actually get the benefit of the corporate enforcement policy. And on top of which, if you're DOJ, and Jennifer, I think, believes strongly in this, what are the types of cases that you want to encourage disclosure for? What's the purpose of disclosure? It's to go after the CEOs. It's to go after the criminals at the executive level. And if you're DOJ and you're saying, well, we're not going to give you a declination if you walk that case in the door, then I think you're losing sight of the overall purpose of the corporate enforcement policy. So I think the simplifying it in the way that they did is making it substantially better. And then the last point that I would make is with the SEC, you're right that there's no disclosure policy, but what they are trying to do, it seems like, is to get back to a much more traditional type of violation. And I think a lot of us felt that in the last administration, there was regulation by enforcement to the millionth degree, and in particular industries, certainly, but even more broadly, the use of the FCPA internal accounting controls, for example, to be used to go after conduct that, when courts look at, and there was a court that looked at it and said, this is not what this was intended for, it's just very rarely that a company challenges the SEC that way. So I think that the steps that are being taken are very sensible, reasonable steps. The question is, what is it going to look like once it gets implemented? I think on paper, the policies themselves, the pronouncements make a lot of sense, but we just need to see what it's going to look like as it's carried out, because I think there are still a lot of questions around that.
Thank you, Dan. And so I have two questions. So one is, so what about the impact of government shutdown? So on DOJ investigation and SEC investigation, is it the same or different? So, and next question is, so I forgot the next question, but so yeah, please answer the first question.
It's good that you want me to answer the first question because I would probably forget the second question by the time I was done answering the first. So the way that the shutdown impacts the SEC and DOJ, it doesn't have as great an impact on DOJ. DOJ prosecutors continue to work. They don't get paid while they're working, so I guess it certainly has an impact on them financially and potentially from a morale standpoint. But they continue to work, they continue to do investigations, they continue to conduct interviews. The SEC, a lot of the staff attorneys at the SEC end up not working through the shutdown. So SEC investigations slow down during the shutdown.
Thank you. I remember my second question. So in a recent guidance from the DOJ, there are some additional procedural burden. So in order to launch new investigation, so they need to get some approval from the higher position from the DOJ. So that procedural burden can affect the how can I say the investigation or detection rate. So no.
So yes and no, and sorry to hedge, but I guess the way that I would look at it is, in theory, that shouldn't slow down investigations. I think it's not unusual, and that's I think an authority that can be delegated. And so, to have the head of the criminal division, someone like Keith or Keith's boss, look at a corporate case before it gets opened and say, this case that you're describing to me is consistent with our policies and with our guidance, so we think it's appropriate to open it, or this one is not. I think that can actually be a good thing because, I think that prosecutors who sometimes aren't as familiar with corporate investigations may not realize the significant impact that even getting a subpoena has on a company. A lot of companies may choose to disclose that. It may impact shareholder price. It may lead to shareholder suits. And so I think there is a real impact of that, and it's not in and of itself, I think, problematic to say, okay, we want the head of the criminal division or some designee to say this is consistent with what we're doing. I just don't know how it's going to be implemented and how much that's actually going to slow down investigations.
I just wanted to ask Dan a sort of a follow-on to that, but open for anyone, which is, I hear what you're saying about getting approval at a high level, and that actually makes some sense. How do you see that playing out within the U.S. Attorney's offices? And what are you seeing there? Because you will hear a range of things like, this U.S. attorney who's following X process is no longer welcome, and also some deference given to some of maybe the newer hand-picked U.S. attorneys.
Yeah, I think so Main Justice versus U.S. Attorney's offices. I think you're right to point that out, Lisa. I think U.S. Attorney's offices are going to be office by office, right? Unlike the criminal division, where you have one head of the criminal division that oversees all of the different types of corporate enforcement. When you start getting into the U.S. Attorney's offices, it really is going to be dependent on who the specific U.S. attorney is. At the same time, I would think that most U.S. attorneys are not going to be offended by a corporate investigation being opened, unless it really is inconsistent with the administration's priorities. Which, again, this is why we have elections, right? You have new people come in and they get to decide what the priorities are going to be, and some people are very angry about it and don't like what those priorities are. Some people may like what the priorities are, but that is going to shape enforcement over the next 4 years.
I think you made a very good point that it is important actually for there to be some, maybe not supervision, but someone coming in and talking to prosecutors about corporate enforcement. That's something I've always thought should happen. And I've always thought one challenge with the CEP is that many prosecutors aren't really taught, why do we have it to begin with? And how do you think about deterrence in a corporate context? Because they're trained as prosecutors. You see the bad guy, they did a really big crime, you should hit him with a stick. And the more sophisticated ones are. But not everyone's in, the fraud section or in the Southern District or Eastern District. Some are seeing a corporate thing for the first time, they're out somewhere else. So I think having a little training and talking about the issues. I'm concerned, though, about oversight by senior political people, because ages ago, 2021, I was asked to write something on, well, why do we need corporate criminal versus civil? What's the difference? And as a prosecutor, you probably think there's a big difference, but as an economist, we go, it's all just money. And the big distinction I saw was who gets to bring the action. And the civil enforcement authorities are much more political animals. The SEC the commission approves everything. And those are political appointees. That's true at many others. And having all these independent U.S. attorneys and somewhat more independent fraud section traditionally has been a good thing because it tamps down, not eliminates, but tamps down politics and enforcement. And it worries me to bring in actors where you can get more ability of companies to lobby to make things go away. My favorite being Purdue Pharma. That wasn't our finest moment, Purdue Pharma 2013. We've seen political interference. So I worry about that.
And sorry, I definitely, Lisa and Alan should
Yes.
speak because they have a lot of value to add here. The one point I would just make is it is not as though the fraud section has been acting independently.
Yes,
There has been a lot of oversight from political appointees over the past few years, administrations. So I don't think that's really a big change.
Okay,
That may be something I haven't seen.
okay. So Alan, would you like to add anything from this point, or we can move forward?
No.
Okay. So let's move on to the UK part, and then I will ask you, Alan, about the recent update, especially focusing on the ECTA.
Yes. Is this working?
Here, let's pass.
Yes, it's working. Great, thank you. So first, can I echo Jennifer's thanks for the invitation. It's brilliant to be here. It's my second time this conference, I can say. It's also one of my favourites, and it's certainly the one I go to with the best artwork. So thanks for that. Very stylish. ECTA, Economic Crime and Corporate Transparency Act. For those of you in the room who are fans of or connoisseurs of legislative compromises, then Economic Crime and Corporate Transparency Act is for you. The reason why it's for you is that the reforms which really impact on corporate criminal liability in that statute came about as a result of the actions of backbenchers in Parliament. It wasn't the government's policy to bring about the reforms. And when you look at the detail and the complexities which are in this statute, they are a reflection of the sort of horse trading that went on as the government understood that it couldn't really block the reforms which were coming through. It also means that it's a piece of legislation which includes failure to prevent fraud, and it lacks some of the sort of simplicity of the failure to prevent bribery legislation which just went through in a simpler fashion. So that's the overarching comment. Two substantive reforms to corporate criminal liability in England and Wales contained in that statute. The first is the way in which economic crimes are attributed to companies. Now, unlike the United States and England and Wales, we have an identification principle. And the idea was that where a company is facing a charge which carries with it an element of fault, dishonesty, willfulness, so on and so forth, corruptly taking the old law, you need to be able to find a human being who is senior within the corporate, whose words and whose actions and whose state of mind can be attributed to the company. So it's not a vicarious liability model such as you have here. And it's always been, the scope of the identification principle in common law was always vague. It was always understood to be someone who's really, really senior within the corporate, somebody to whom, someone who didn't answer to anyone else within the corporate structure. The Barclays prosecution, the SFO Barclays prosecution, which I was involved, was the apogee of that, and caused some uproar within academic circles about, well, haven't we just abolished corporate criminal liability by the way in which, the very strict way in which the judge approached the question of authority within the corporate. The form is the substance, he said, well, in which case it's pretty easy to make responsibility for someone who's well away from the senior people in the business. The response is a statutory test now of senior manager. That is something which applies only to economic crimes, the first of the compromises. And the reason for that compromise is because it was an instance of the government being essentially hijacked. They were passing an economic crime act or an economic crime bill. Our parliamentary rules don't allow addition of reforms which go beyond the scope of the bill before Parliament, so it has to be limited to economic crimes. We now criminalise a company by way of the identification principle if a senior manager acting within the actual or apparent scope of his or her authority commits an economic crime listed in the statute. That then is attributed to the company. And the question then becomes one of what is a senior manager? And that's where the fights will be, and that's where people are agonising now. A senior manager is someone who plays a significant role in either the making of decisions about how the whole or a substantial part of the activities of the company are managed or organised, or the actual management or organisation, the whole or a substantial part of those activities. That's obviously wider than the common law, but where the line is drawn is going to be something which is going to be litigated. And the Serious Fraud Office was indicating very clearly before that came into law that they were going to stand and fight on that. That's fine. But when you're advising corporates right now, there is always an element of judgment ultimately about whether that statutory test is met, and it's quite difficult without guidance. Please.
May I ask a question on this? Because interestingly, I had a software client in the UK, a very large UK-based company.
Yeah.
And when we talked pre-September 1st, and when we talked about ECTA, the chief senior compliance person said, we're not worried about it. It's an auditor thing. It's related to financial statement fraud. It's an auditor thing. And I just couldn't believe that. And it's funny, last year there was a conference here in New York where an SFO representative was there, and I quietly went up to her and asked her, is this really only related to the auditors, or when you wrote this, is this really, does this include bribery and corruption? And she looked at me and she goes, you gotta be batshit crazy. And she used those exact words.
Really?
Batshit crazy, you think this is for the auditors. Again, I kind of relayed that message subtly back, but this is not an auditor, I think the company was wrong, this is not an auditor issue, it's a compliance issue.
It's absolutely not, and when you look at one of the problems I have with the guidance on the failure to prevent offence, which is entirely distinct to this sort of model of attributing crime to a corporate. The two are in parallel. One of the problems I've got with the statutory guidance, which I'm going to move on to in a minute, is that it fails even to acknowledge the existence of this. It doesn't flag that, as it's telling people to assess risk, to put policies and procedures in place to manage the risk, it fails even to acknowledge the existence of Section 196 and the way in which the attribution principle has been widened. There's a lack of understanding about it.
And again, actually that SFO person said, she took note of that, of like, hey, we'll maybe provide more guidance, who knows what will happen, but I think there needs to be some clarity. I mean, if a big company thought of this was just for the auditors, and financial statement fraud versus bribery and corruption, that's a big miss.
It's foolish. It's foolish because, you know, these are two distinct, separate reforms, tackling two distinct, separate things.
Yeah.
And they've got to cover their bases on both. Agree?
I agree, and I think one thing that might be worth commenting on is that I think, unlike the US, can you hear me back there? Yes, you can. Okay, great. Unlike the US, where we have a whole history of very, very detailed guidance, what counts, when do you get credit? And Jennifer's pointing out that, you know, it's nice to have certain up or down quality to some of that. But we know over the years that there have been roadmaps formulated for all of us to get a sense of what do we really need to do to get credit here, to be considered a good compliance program. I think Ellen's pointing out quite correctly, not only is there arguably a disconnect between these two changes in law, and by the way, the one thing we didn't mention is the new ECTA just came in September 1st. So this is brand new, and the change in attribution was at the very end of 2023 by UK standards, again, quite new to the party. So these are new features, we're all learning about them together. But if I can just make one substantive comment, in the UK, we really didn't have, and I believe still don't have, that kind of detailed roadmap where a practitioner like Alan can sit down with his client and say, you know what, we know exactly what we need to do here. What we've ended up instead, and I appreciate you think UKPA, the Bribery Act is clearer and is different, but in one way the two are the same. They're really governed by just 6 basic principles about how to do things right from a compliance standpoint. And it's very basic stuff. From my view, having spent a lot of time within financial institutions, which is, you know, good tone from the top, proportionate understanding of risk, and making sure you have the right resources up against the different risks, and you know, good due diligence, have some monitoring, rethinking, again, very basic, kind of basic pillars, which I think you could say could be helpful, because in the right hands, you can fashion a program that really makes sense and is the right fit for the company. But if you really want to advise on what's the government going to do here, it is quite helpful to have a little bit more detail.
So, and I agree with that, and we see that make some comments about that in respect to the policy specifically on failure to prevent fraud. But as I said, there were 2 changes. The first, the attribution principle, the statutory senior manager test, and then as you've heard, on the 1st of September, came into force the failure to prevent fraud offence, and this was really the subject of some serious horse trading. It is an offence which takes 2 forms and can be committed in 3 different ways. And one of the particular fruits of the horse trading is an offence that can only be committed by a large organisation. So this was the Treasury sort of its final throw of the dice, which it always hated the idea of failure to prevent fraud, and it hated the idea of criminalising corporates. It was that its final throw of the dice was just limiting it to large companies and thus excluding most companies in the United Kingdom from the ambit of that particular offence.
Can I just put a footnote of it was so painful to be sitting in the chair as director, watching this grow and getting excited that this law was actually going to come into force, and you know, and to see that sort of. But it's got to be a huge corporate to really be effective here. It was absolutely heartbreaking.
And it was also quite fun, as someone who's ex-SFO, sitting in conferences and watching very professional former colleagues with a straight face saying, no, I think this is fine, it's proportionate, they share a panel with people from other departments in the United Kingdom government, and they sort of quite good at hiding their sorrow at what this particular limitation was. But anyway, let me just tell you a little bit about it, because it sits conceptually, for those of you who enjoy various theories of attribution. This is a vicarious liability model tempered by some sort of conduct defence. So the offence is committed when the relevant body, this simply means a corporate or a partnership, sort of massing it in both, which is a large organisation, is at risk where in a financial year, will commit an offence where in a financial year, that is important because that goes to whether the organisation is a large organisation. I'll expand on that in a second. But you then go to, and the person associated with it commits a fraud offence, and you need an ulterior intent. And there are two available ulterior intents. One is to benefit the relevant organisation, so it's the associated person committing fraud to benefit the corporate. Or it is benefiting with the intention to benefit someone to whom or to whose subsidiary the associate provides a service on behalf of the relevant body. So it could be an employee of a bank who is committing a fraud in order to assist a client of the bank. And it emphasises the service nature of the offence. I'm not quite sure why that was put in, but there you go. That offence is committed in two ways. Caught within the scope of a large organisation is a group of companies. And so you might have at the head of a group a relatively small company, but which is the ultimate beneficial owner of some really substantial corporates. And so the law is drafted in such a way to capture the group model as well. And then that creates a weakness, and the weakness is that you might have someone who's working for a subsidiary company who doesn't really care about where the value lies, and their ulterior motive is simply to benefit their employer. And that's the third way in which you commit the offence. If you are an employee of a group, or if you are sitting in a group company, you don't yourself need to be a large company to meet the test of a large organisation. But if one of your employees commits a fraud intending to benefit you, and you sit within the group which meets the definition of large organisation, that too is a crime. So you can see the horse trading going on. The importance of the accounting period is that at the end of each accounting period, you will take stock of what your balance sheet is, what your turnover is, and it is by those sorts of standards that we define a large organisation. It's taking principles from company law and writing them right across into the criminal law. So the test is a balance sheet, a turnover of more than £36 million in a year, a turnover of more than £18 million in a year, or and more than 250 employees over the course of the year. You need to meet 2 out of the 3. So every year you look at your accounts. This is what's do I meet the test? And then that following year, you're a large organisation, you're at risk of the offence. See the compromise, lace through it. I mentioned associated person. That's a really broad definition, anyone who provides a service for or on behalf of the company. It definitely includes an employee, an agent, or a subsidiary, but it's much broader than that. And the defence is the defence that you have in place reasonable procedures, or it's reasonable in all circumstances not to have any policies in place. I think you're mad if you want to rely on that, and certainly mad if you want to rely on that without having conducted a risk assessment, one of the points Lisa touched on. By law, the Secretary of State, so a senior minister, has to issue guidance. And this is what Lisa was referring to in respect to the Bribery Act. The Bribery Act was the first way to prevent offence. The approach of the government was really to lift the scheme in our money laundering regulations and carry it across to anti-bribery. So, tone from the top. risk assessment, proportionate risk-based procedures, due diligence, communication including training, and finally monitoring and review. Those are the 6 principles. And it's fair to say there's not a lot of unpicking of that or unpacking of that. In the guidance we've got exactly the same principles in the failure to prevent fraud as for failure to prevent bribery, and indeed failure to prevent facilitation of tax evasion. A couple of things about it. There's some guidance there about theories of fraud, which is probably quite helpful to some people, and also some pointers to third-party resources, which is a bit of a departure for the government. But look, talking to people who are within companies at risk of this, they had really very little understanding of criminal liability. It's not been an issue for them. The guidance purports to give an account of where their legal risk is. It doesn't, for example, mention that this effect, the failure to prevent effect, sits within a sea of greater risk of attribution. It's completely silent on that. I think it butchers in an attempt to be simple and clear, it butchers the description of the scope of extraterritorial jurisdiction, which means that I don't think people get a fair assessment of risk there unless they really go away and either hit law books or pay lawyers to tell them what the government should be telling them. And it doesn't accurately describe the full extent of the offences which you are meant to prevent.
Could I just add a little color on that? I mean, which I think is fine. Bottom line, government was supposed to come out with rules and regs, and it required, I don't know if you recall, Edward Garnier was here last year, a question had to be asked of the government, sort of where is this guidance? For somebody in government to say, oh, gosh, we better get at it. Yeah. So it was only after a lot of prompting that they sort of woke up and thought, we better move this thing along.
Yeah. Well, I mean, just before we move on to the high point, just to add to that, Carla, we've also had a change in government. So the last government under which this was passed was desperately anxious to get this law on the statute book before it disappeared, but its first attempt at the guidance was not good. And they were persuaded to withdraw it and to think again. Then the new government came in and said, well, we know much better than you. And they, their first attempt was not good. And they went away and had to think about it. But then they too wanted to be under that pressure. And I think it's important because such guidance as has been produced was produced quite a short time before large organisations could really look at their wiring and make sure that their policy frameworks were in place and active before this became law. And I think there's a risk there for the industries which are being impacted by this, particularly multinationals who have a very much more complex sort of compliance wiring and structure and the difficulty in understanding just how you're going to be able to accommodate this within what is a pretty multifaceted sort of risk analysis.
Lisa, can we send you back and fix it?
Thank you. Thank you for completely overestimating the power, although it's interesting because we now know my successor is out there saying, I want to be the Mikhail Gorbachev of the future. I want to be making deals and I want corporates to self-report. Again, really trying something that government after government is trying to do, which is to get companies to come in. It obviously saves the government a certain amount of legwork if they have folks coming in to self-report. And we know that this current director is out there saying that if a corporate self-reports and cooperates, unless there are exceptional circumstances, a deferred prosecution agreement will be yours for the taking. So I think it gets a little closer to your wish for certainty of a sort. We don't know really what exceptional circumstances means. These are all wiggle words that we know can attach to different behaviors. But I think there is an attempt to try to mirror some of what has been a cottage industry in the US, which is walking in, self-reporting, and getting a certain result.
Okay, so I think that point should be discussed with hypo. And so I circulated so the hypo page, but I hope you take a look. In short, so the hypo is a company, is a UK company, not only in UK but also in US. And then so they got a whistleblowing anonymous report, and then so from Mexico. So and their Mexico company subsidiary, so there's a potential XCP evaluation. And then so it looks like the case exists. And the question is, so what we should do? So I'd like to ask first, so the main but most important question is so whether or not we should disclose the case to the DOJ, or so what is your impression? So what is your advice?
Yeah, and I think Jennifer hit on this, which I think is the right analysis, which is how likely is it that DOJ is going to find out about it anyway? And then the other part of the calculus is what is the delta between the results you would get if you voluntarily disclose versus if you don't voluntarily disclose and they find out about it anyway? Because even if there's a high likelihood of detection, if the delta in the result is not going to be different, then it's worth the risk of not disclosing. And the flip side is, if there's a very, very low likelihood of detection, maybe you choose not to disclose anyway. And I think, I do think that the corporate enforcement policy has taken steps to increase the carrot and make it more desirable, a better outcome if you do disclose. I also think, DOJ has kept in place the whistleblower program. I think they're trying to encourage whistleblowers to come in, which increases detection. But I also think you need to look at all the other pieces. So Jennifer mentioned the fact that the SEC doesn't have a voluntary disclosure program. You heard Alan and Lisa talk about the SFO. And so if you're disclosing to DOJ and it's a UK company, there's a very, very strong likelihood that there's going to be coordination and that the SFO would be looking at this as well. And if the benefit to you at the end of a very long investigation after, some of these investigations last years, they cost a lot of money to cooperate with DOJ and the SFO. If the result you're going to get is a deferred prosecution agreement in the UK with a lot of obligations, maybe that's not that desirable. So I would think that you would be looking very strongly at how likely is it that this is going to come out anyway. And if this is coming to you through a whistleblower report, it depends on what that whistleblower looks like. Is it someone who is saying who they are and they're willing to meet with you and they're really concerned about the company? Or is it an internal report that makes it seem like they're about to run to the authorities? And I think that could be one factor that could tip the balance.
So I have to agree with everything you just said.
Thank you again.
I know where the expertise lies. The DOJ, there's one aspect of the CEP that I was very struck by, which is they do seem to be trying to increase the delta in both directions. And if I may just put a plug for the ALI's Principles of Corporate Enforcement, which came out this year, which also tried to do that and said, if you don't self-report or cooperate, you are guaranteed not to get an NPA or a declination. And CEP is trying to make it clear that you cannot get a seriously reduced fine if you're not self-reporting. So they are trying to increase the incentive, but obviously you're right. The big thing you're looking at is, if you self-report, is the SEC, the UK, and sometimes other countries. On the whistleblower, I agree that the big action is two things. Did the whistleblower likely report to the SEC? And is the SEC going to pick it up? On whether the whistleblower reported to the SEC, we don't know a lot about what causes them to do so. Sometimes they're reported simultaneously. In part, that really helps them keep their jobs better. because it triggers all sorts of protections. But we do have some, I can't say it goes to data, but anecdotal experience out of companies that people who reported to the company in good faith and had no interest in reporting to the government may come around and change their mind if their company disappoints them by not looking like an ethical company. I mean, if they think they see genuine wrongdoing and you dismiss them, and particularly if, as often happens, their line manager figures it out and then proceeds to make their life miserable, they may get really mad and report to the SEC. Whether you should worry about that, I think, depends on whether this is a case the SEC is going to pick up. Because if the SEC doesn't pick it up and get over $1 million, you don't have to worry about it. And it probably won't find its way to the DOJ, and therefore won't find its way to the UK. So if you think it's a case that the SEC is going to let die on the vine, they get thousands of these things, you might be okay.
Great. And if it's a real case, and if I were a counsel, so I would invite you as a US counsel, but also you, so Lisa and Alan, so the UK counsel. And so it's not only US issue, but also UK issue. And I'd like to ask you too, so you both, so what is your advice? So when discussing whether to not, so we disclose the case to UK authority or not?
I'll make mine quite short. I think, first, in terms of whistleblower, different countries obviously have different approaches to whistleblowers. So in the UK, you don't get financially rewarded for blowing the whistle. I know that in Japan, it is not at all condoned. It's seen as you've had a cultural failing if you have someone raising their hand and blowing the whistle. So that'll really depend on where you sit. I'd say it's a very risky approach to voluntarily disclose and think you're only going to be disclosing in one jurisdiction. I just think our history of working across the globe and with authorities in different countries shows that you ought not be taking comfort from the fact that, I'm only going to tell the SFO and it'll never get out beyond that. I would also say, in general, the SFO, although it's had a bit of an uptick in resource, is still an underfunded organization where it will behoove the director, whoever he or she may be, to encourage self-report.
Yeah, I mean, just generally, Dan described exactly the same approach that English lawyers would give. We'd be giving the same advice. I don't think there's a world in which you would agree to make a report in one country, one jurisdiction, and not the other. Once word is out, you might as well just make sure that the reports go in to the people who might take action against you. And specifically in terms of the policy which Nick Grave, the current director of the Serious Fraud Office, has put out, very clear that the self-report means a self-report to the Serious Fraud Office. They're not interested, he's not interested in a report made to other people, which gets sort of picked up on grapevines. They wanted to have the report made directly to them. Makes no sense not to report to both.
Yeah, I was going to say, I think the one strategic point that makes it even more interesting, I know maybe you were about to get to whether or not there are cartels involved. If you learn that there are cartels is one of the next questions. I think the interesting strategic decision is, what if this is an area that is not a focus of DOJ's priorities? And so if you take the cartels out of it and you just assume that you're looking at potentially gifts, travel, entertainment, that seems to be outside of the priorities of DOJ's focus, unless it's in a national security context, or unless it's a situation where a U.S. company was beat out for a contract as a result of it. But assuming that that's not the case, the question then becomes, does it make sense to run into DOJ, get a declination in this administration, because if you don't, maybe a new administration comes in, gets rid of those priorities, and now you're back in sort of the world where everything is a potential violation, everything's a potential case, and now you haven't voluntarily disclosed. And if the whistleblower goes at that point and says, now I'm going to run back to DOJ because they're more active, then you end up potentially with a worse scenario. Now again, that's a lot of ifs, and it's a lot of looking down the road. And I think when you're at this stage, if you're 3 years away from the next administration, it's a lot easier to say, okay, maybe we shouldn't focus as much on that particular factor. But as you get closer and closer to the next administration, maybe that does become a driving force, as well as we probably want to wait and see how this administration is actually going to carry all this out. Because again, we want some comfort that if it is a case that is outside of the key priority areas, the DOJ is just going to say, thanks but no thanks, we'll send you a letter saying we're not interested, we're not going to bring a case.
And you might also question what industry you're in for that, because if you're in crypto, and like me, you woke up and, found out about the new Binance resolution or the approach, you might think you're in areas where it would make sense to self-report and get it over with, and that it will be fairly hard to unring that bell 3 years into or more of supporting a particular industry or facet of financial interaction.
Great. So we already started discussing the number 3, but so do you want to add anything?
So, again, not being the person in practice, but I would think it would change my view, because I think if you have an internal report, if you just have an internal report that says, I saw Joe Smith, my colleague, doing this, and I don't know, is this okay, is it not? You might be okay, because that's not really indicating they think there's a problem. But if you have an internal report that indicates they think there's a problem, I do think you have a really strong risk that if you don't deal, that person, even if they haven't already reported, will report, in which case the calculus of risk is what are the odds the SEC picks it up. If you've got ties to Mexican cartels, the chances that the SEC picks it up, I think, just went way up. So now I think you really would want to self-report in the US and pretty promptly. And then
No, I agree that if there is a whistleblower report that's going to DOJ or SEC that mentions cartels, there is a much greater chance that it is going to be something that gets picked up.
Okay, so I think that means that when we deal with the internal investigation, so what we should investigate can be such as with priority. So I think when we advise the Japanese company, for example. So my question is, so what is your third party, and what kind of relationship you have, and what is the third party's client, and so do you have any information about that? So I think that kind of additional information is now very important.
I just want to ask Danica, because I think it's not just your third party, right? So you have company Z has ties to the Mexican cartel, but as I read it, and correct me if I'm wrong, if you're bribing government officials or foreign instrumentalities who have ties to cartels, now you have a problem. And in certain countries, if you're bribing government officials, if you have government officials who are taking bribes in high cartel countries, dollars to donuts, those government officials, to use the technical term, are taking bribes from cartels, right? If you're a bribe-taking guy, you're a bribe-taking guy, right? And now you're in cartel. Yeah. Well, in your experience, looking far at other bribe-taking guys, right?
Yeah, I think.
It's the foreign official too that's a problem.
Exactly. It's the foreign official, it's the third party, it's any link to a cartel, which again, when the executive order came out, I think we were all wondering how it was going to be implemented, and the Attorney General's memo on cartel, the link of cartels and FCPA, what does that mean? It has been answered in the form of very broadly, right? Any connection to cartels and TCOs. I guess I agree that if you're taking bribes, if you're taking cash bribes from a company, there's a pretty good chance you're taking cash bribes from other people. If it's a high cartel risk area, there's a pretty good chance you're taking cash bribes from cartels. Again, I view sort of speaker series and gifts, travel, entertainment as potentially different.
Yes.
But I agree with you in principle.
I thought I might think we would add a slightly different perspective to the fourth point with regard to how much investigation you would do. I think my predecessor, the person with whom you worked, was on record as saying, don't trample on my crime scene. In other words, don't think about investigating, more or less. I think that was the message, and I think Alan can probably give us a little more clarity on that. I think in my view, I had a slightly different view, which is you find out there's a problem, you need to get at least some handle on what it is before you raise your hand and go reporting it out elsewhere. But I thought it might be a helpful perspective to bring.
I don't think that's what David was saying. So David Green, Lisa's predecessor, I don't think of investigating. The first DPA we got was against Standard Bank, and when the really outstanding piece of cooperation in that case was a really, really good internal investigation, which involved bringing to us a lot of evidence from Tanzania, which we'd never have seen, using mutual legal assistance mechanisms, because the corruption went to the top of the government, and it was nonsense to think that they would, if we'd asked for them to investigate the bribes in question, that they would have given us mutual legal assistance. So there's a time and place for it. What he was targeting at was sometimes the way an internal, I'll express it this way, when sitting in the SFO there can be a perception that an internal investigation can be presented as a whitewashing exercise, and some witnesses can be schooled during the course of being interviewed several times. I can think of a case where a witness was interviewed 13 times before they were presented for interview by the Serious Fraud Office, and amazingly, it was as if they were reading a script when they were interviewed. We were also denied access to their previous 13 interviews because privilege attached. That's what David was talking about, and that's why we were anxious when making clear expectations that we were very keen on a waiver of privilege over witness accounts as a significant mark of cooperation for by a company. I think then we're probably going to sort of coalesce around how much investigation is needed. It's as long as a piece of string. If you get a piece of nonsense on a whistleblower report, which with a little bit of review by the corporate sort of disappears into the mist, then no law enforcement body wants to know about that. But if you are going to investigate and you really do start to look as if there's something there, then they certainly appreciate being told that it's coming and that there is something they're looking at. Sorry, just whilst I've got the microphone, just going up to question 3 in the cartels. I mean, what that question does as well is sort of raise the spectre of other crime types. And there is a particular sort of pervasive crime type certainly sitting in the United Kingdom, which is sanctions. And if you've got a situation where instead of dealing with cartels, you're dealing with Russians, where we've got very extensive sanctions regimes, then you want to be very alert to not just bribery, but to potential sanctions evasion. And once you get into potential sanctions evasion, then you get into an entirely new regulatory scheme where a number of different professions are subject to duties, legal duties, to report to the United Kingdom government suspected breaches of sanctions, bribes, payments. There are assets freezes over people. So you need to be very alive to the way in which the nature of the allegation can spread into something which completely changes the dynamic, because it's a crime against report, a suspected sanctions breach if you're subject, if you're working in a profession which is subject to those reporting obligations.
Great. So I wanted to ask some practical question. Because so when we receive the whistleblowing report, which is anonymous, so it's very not easy to investigate the case and identify what's the fact. And in many cases, so whistleblowing report is not so good report. So, but I'd like to know what kind of challenges you face. So when dealing with a whistleblowing report, which is anonymous. So so how do you address that issue and to get enough information to decide to voluntarily disclose the case or not?
Yeah, I think it's a great question, and sometimes it's very hard depending on how ambiguous the allegation is. And so one thing you can always do, and it's good to do this regardless, is write back, realizing it's an anonymous address, an email address, but to write back and to ask follow-up questions. That is the first step of investigating, and you can always say to DOJ, if they do come knocking at some point, that you tried to follow up for more information and you weren't able to get it, depending on whether the whistleblower provides more information. But it could be as simple as if the whistleblower is alleging that, in this case, that there was gifts, travel, entertainment in order to procure a particular license or project or referral, you can start by looking at the timing of that referral, at what, sort of just the business aspect of it, and see if it even in fact matches up. Sometimes whistleblower reports on their face are just wildly inaccurate. They say that, oh, this consultant was hired to, and was paid $2 million, and you look and it turns out that the consultant was hired and paid, $20,000. So, there are things that you can do just to pressure test the general aspect of it without having to do an in-depth email review or conducting interviews.
Thank you.
Just a footnote on that, which I have to tip my hat. I got this from Eugene Soltis, who will be here later, so this is not, but he's looked into how to get more information out of anonymous whistleblowers, and it really matters how the question is asked. So do you just say, anonymous person writes back, or do I say, hi, this is Jennifer. I'm in the investigations unit. Thank you very much for your report. We're taking it very seriously. I have the following questions, feel free to write back, and giving your name where you're already personalizing it, making it into a relationship, turns out to help build trust. Whereas if it's just some anonymous person, maybe even a chatbot, you're not going to build trust as much, and that really matters.
If I could just,
And just because it's not the 2 million, sometimes even the lesser amount may be cause for doing some extra legwork. I know when I was inside at Goldman Sachs, we might not get the perfect factual scenario reported up, but boy, it behooved us all to do some further looking to see what was really there. Not as a matter of, wrong, you're out, but boy, maybe we should do a little sniffing around. Okay, one other, which again comes out of some of the work Eugene's been doing,
which is, and actually it comes out of talking to some folks at, I think it was either, I can't remember if it's the SEC or the fraud section, when they look, which is, there's a tendency to just look at this complaint as opposed to looking around and, you know, now we have data and AI. Have there been other complaints in this unit? Because it's often bad barrels, not bad apples. Do we see other complaints in this unit? You're just trying to test, how deep should I dig? Are there other complaints about this person, not just about bribery, but, you know, he found if people have a lot of unsubstantiated sexual harassment complaints, you ought to follow up on this one, because they're a rule breaker. You know, that's a red flag that this might be worth digging into. So looking around a little, which now you can do a lot more quickly than you could do before.
Okay, thank you very much, and I think it's time. And again, so thank you very much for sharing the really good input for various perspectives. And yeah, I hope this is helpful for you all. You all. Thanks so much.